Oh yay, oh yay, oh yay. The Special Court of Review is now back in session.
Good afternoon, everyone. We're back in session. Justice Parker, I trust everything's okay with your court?
As far as I know.
Okay. Let's see, Mr. Robertson, you were asking Mr. Olson about, I guess, that he asked the judge to be escorted. Would you like to continue there?
Mr. Robertson, you need to unmute yourself.
Thank you. Mr. Olson, you've told us that you had that you asked to be escorted from the courthouse. I just wanted to get back into the courtroom for just a minute. Before you left the courtroom and or before Ms. Carol Smith left the courtroom, did the judge announce a resetting of the case for another day or time?
No, sir.
You didn't hear an announcement from either the judge or a clerk or anyone to be back on May the 14th, 2019?
No, sir.
Okay. How did you learn of the May 14th, 2019 hearing?
I got a letter in the mail.
All right. Let me ask.
Yes, a letter. I received a letter in the mail, and it was a copy for me and my brother.
All right. Let me ask Ms. Thomas to put up Examiner's Exhibit 7 that's already been admitted into evidence. Are you able to see that?
Yes, sir.
Okay. And if Ms. Thomas, if you'd roll down, please. All right. Now, looking at that envelope and then back up to the notice itself, Ms. Thomas. Is that the notice that you received in the mail?
Yes, it is.
All right, sir. Mr. Olson, if the court didn't announce a reset in the courtroom, what did you think this was?
I thought it was a notice that she was attending court for her behavior. And that's why I was receiving I assumed a courtesy copy. I see CC at the bottom, but I didn't see a Texas seal on it or anything. So I didn't think it was official that I needed to show up.
Okay. Does it say anywhere in that document that you're ordered to show up?
No, sir. I didn't read anything that said that.
Okay. And did you receive an oral notice from the court that you were ordered to appear on May the 14th, 2019?
No, sir.
All
right. Mr. Robertson, can you give me the exhibit number and the page, please?
Yes, ma'am. That's Trial Exhibit 7. I'm sorry, Examiner's Exhibit 7. That's already been admitted, and they're not paginated. It's just the document and an envelope.
Thank you.
Let's see. Mr. Olson, did you learn that a writ of attachment had been issued for you?
Yeah, I think it was 2 years later or a year and a half later, I realized that had been issued.
Okay. Do you know what that means?
I learned here recently that it was, they could arrest me, I guess, if they pulled me over.
Okay. But that was never served on you, was it?
No.
Okay. And have you heard what has happened about that writ?
I heard it's no longer on the books, I guess.
Okay. All right. I'll pass the witness.
I've got a question, Mr. Olson. When did you receive Well, you never received the writ of attachment, but how did you learn about it?
Through the dealings here with Mr. Robertson. He mentioned it, and this is the first I've heard of it or seen it when he showed it to me on the computer,
Okay.
on the phone.
And going back to exhibit number 7, the one that's before you, was there anything included in the envelope with this notice?
This notice, there was 2 copies of this notice, one for me and one for my brother, I guess. That was all that was in the envelope.
Thank you, sir.
Thank you.
Before we go to cross-examination, any questions from the justices?
I have no questions at this time.
No.
Okay, Mr. Richmond, would you proceed, please?
I will, Your Honor. Could we bring up our exhibit number 3, which is the original complaint that was filed with the commission?
And that's in the appendix. Mr. Cruz, can you bring that up?
Judge, if I can help, it's our trial exhibit number 1.
You want to go ahead and put that on, Ms. Thomas, so we save time in this trial?
Ms. Thomas, can you do that?
Can we go down to the bottom, the actual written part of it? Yeah, there you go. That's good. Right there. Thank you. Now, Mr. Olson, I direct your attention to the next to last line on this complaint. This is the complaint that was filed with the commission. Is that right?
I didn't do any complaints. That would probably be my brother.
Okay, well, let me direct your attention to
Okay.
the next to last line. And it says, I just appeared on April the 2nd. Was your brother at the hearing? He was in California on April the 2nd, wasn't he?
Yes, he was.
Okay, so you're the only one that appeared at the April the 2nd hearing, isn't that correct?
That is correct. Yes.
Okay, and it says with a violent result. It was you that had the violent result that you were complaining about, not your brother, isn't that right?
That's correct.
And it was you that was escorted to your car
Yes, sir.
and not your brother, isn't that correct?
That is correct.
Okay, so all of those I's are you, is that correct?
Yes, sir.
And it says, I submitted a complaint.
Ah,
Yeah, agree. Okay,
yeah. I've never read that, sir.
okay.
Um,
Now, it says, up above that, it says, I am being summoned to court again in May for a hearing. Now, that I is you, isn't it? Your brother wasn't summoned in court in May, was it? It was you that had to come back.
I'm not sure if he was summoned to court or not, but I guess, yes, I was.
Okay. And that this is, could you go down a little bit further? On the scroll, there you go. This complaint was made in April the 15th, 2019. That would be a month before the May hearing. Is that correct?
I guess so. Yes, sir.
Okay, so a month before the May hearing, one of the things you were complaining about to the commission was that you have to, they keep making you come back and you got to come back again in May.
I object. That's a misstatement of the facts.
Well,
Okay, what is your response, Mr. Richmond?
it's not a misstatement of the facts. I'm reading
It is.
what it
He did
says and what he
Complaint.
just said.
Wait,
that-
wait, Mr. Robertson, let him talk.
He just said that that was him and it was about him, and he's the only one that had to come back to a May hearing. I was just asking him how he knew in April that there was a May hearing. That he
Yeah.
had to
Note the
return.
name at the bottom of the exhibit. It's Norman Olson, who made
Your
the
Honor,
complaint and filed it with the
Wait a minute, Mr. Robertson, wait a minute.
It-
I'm going to deny your objection, overruled.
Thank
And
you, Your Honor.
please continue, Mr. Richmond.
Thank you, Your Honor. So when you say to the court, or you just testified to the court that you didn't think you needed to show up. That's not correct, is it? You knew you needed to show up. You were complaining to the commission in April of 2019 that you had to show up too many times. Isn't that
Object
correct?
Again, Your Honor, there's no complaint to the commission from this individual.
And he has so testified, but he can answer the question and he can clarify that.
Thank
So
you.
overruled.
Thank you.
I never sent this email or read it before my brother sent it.
So do you have any idea why your brother was saying, I did this and I did that when it was you?
I was in court representing my brother, and that's why I'm assuming he was using the I word as if I was him.
I see. So this complaint really isn't you. It's from your brother. Is that what you're saying?
That's correct. I never had any dealings with Miss Smith. I never had a contract with her, and my brother did.
Okay. Now, in this complaint to the commission, did either you or your brother ever complain that you didn't receive notice of the April hearing?
No, because I received notice of the April hearing in my mailbox.
Okay, so you did receive notice of the April hearing. We established that. And you got that show cause notice that said it's set for April the 2nd. You got that. You're admitting that, right?
Oh yeah, and I showed up for court that day.
Okay, good. Could we please put on
exhibit number 10.
Oh, wait a minute. Before we leave this exhibit, let me ask you another question. It says the court has been hostile, and we have been escorted to our vehicle twice by an armed bailiff. When was the other time?
The first time I was in court with Miss Charlotte Smith. That's when I had to be escorted the first time.
Well, what date was that?
Oh, 2013. I can't remember what month.
So you weren't escorted out. Are you saying you were not escorted out on the April 2nd hearing?
Yes, that was the second time I was escorted out because of her.
Okay. Was that also because you were frightened that she was going to do what? What were you frightened about?
I didn't know who was in the parking lot, sir. I just wanted to be escorted to my car.
Okay. Did you ever mention in this complaint or at any time that that was just an oral motion for contempt and you felt like that wasn't fair or reasonable?
No, sir. I never complained.
Okay. Did you ever mention, well, you've already said you did get notice for the April 2nd hearing, so you certainly didn't complain to anybody about that. And what's the show cause here?
Exhibit 10.
And could we pull up exhibit 10, please?
And exhibit 10 is the show cause notice. It's trial exhibit number 3. Ms. Thomas, if you can put that up, we really would appreciate it. Is that it, Ms. Thomas? It's a show cause notice.
I'm sorry, Judge.
Yes, Your Honor, but our trial exhibit number 3 is not that. That's the whole document. So I'm trying to remember where it is in ours.
It's our exhibit.
Our exhibit number 10.
It's our
Yeah.
exhibit number 10.
But they don't have it, so hold on. The show cause,
I think it's these. Here we are.
There we go.
you got it? Okay, there you go. Is that it, Mr. Richmond?
No, there's
Scroll down.
wait a minute. Yeah, there you go. It's that one.
Okay,
Okay, for the record, what are we being shown?
it's the equivalent to Mr. Richmond's exhibit number 10.
But where's it coming from?
Judge, it's our exhibit. Roll down a little bit, Ms. Thomas.
It's trial exhibit number 3, 8 pages 89 through 94.
Okay, thank you.
That's
All right, now-
specific page is 94.
That is the show cause hearing that you received, isn't that right? Telling you to be there on April the 2nd, right?
Yes.
Okay. Now, in that show cause hearing, it says that you're ordered to appear before the court to show why the defendant should not be held in contempt by this court for failing to complete and return the interrogatories as the court ordered. Is that what it says? And that's the notice you got, right?
Yeah.
And so you knew that when you went to court on April the 2nd of 2019, you were to explain to the judge why you should not be held in contempt for failing to return the interrogatories to the court. That's what it says, isn't it?
Yes. And when I arrived to court, I never received any interrogatories, and I was never asked any questions by the judge about that.
Sir, please just
Yes,
answer
sir.
the questions that I ask you.
Okay. Yes, sir.
Now, did you ever tell the court or the commission or anybody that you had no idea what interrogatories they were talking about?
No.
Did you ever tell anybody, I was never served with any interrogatories?
No.
Do you understand that the purpose of that hearing was for you to tell the court all these things that you're now telling the commission? Excuse me, now telling these judges. Now, did you tell the court anything about the documents were misnumbered or the dates were wrong on any of the documents?
No, I was never asked any questions, so I never told them any answers.
Well, the reason you were there is so that you could explain why you should not be held in contempt for failing to complete the interrogatories. It was up to you to tell all these problems that you had to the judge as a reason why you didn't answer the interrogatories.
I was asked.
And you did not do that, did you?
I was only asked why I was there in court that day, and I said I received a letter in the mail. I was never asked about anything
sir,
else.
I understand. Please answer the question.
Mr. Richmond, let me please ask you, I'm the one that should tell the witness when to answer, okay?
Thank you,
Please don't give any instructions to the witness.
I
Just make your objection. If it's-
I object, Your Honor. It's not responsive to the question.
Okay, Mr. Olson, just answer the question, please, and we would appreciate it.
Okay. So you were aware of the fact that the purpose of this hearing was for you to explain to the judge why you should not be held in contempt for failing to answer and complete the interrogatories.
No, I was not aware of that fact.
But it was in the document that was served with you. Is that correct?
Yes,
Sure,
it said that in the document, and I didn't know what that meant.
Okay. Did you ever retain a lawyer in this case or ask a lawyer what all these things meant?
No, sir.
Did not. So you had this show cause notice, you said in March. Do you remember when in March that you received this in the mail?
It's on the envelope, the date, I think middle March, early March, something like that.
Okay, so you had it for almost a month. But you did
yes,
not
at least 2 weeks, yes.
Okay, and you did not ask anybody what it meant or talk to a lawyer or anyone else?
No.
Okay. Now, you said that the notice you got, you didn't believe that you needed to show up for that.
Which notice, Mr. Richmond?
He testified the notice he received for,
May 14th.
oh,
the-
excuse me, no, that's the May 14th hearing. I'm sorry. Now, you're in property management, is that correct?
No, sir. I'm not in property management. I take care of a couple properties for my brother who's out of state.
Okay, what is the level of your education, sir?
High school diploma.
Okay, and I assume that you can read and write.
Yes, sir.
Okay. Okay. Now, you said that you did not know of any oral resetting or any resetting of the May hearing. When you went in for the April hearing, there was some testimony that the judge reset it to May in orally from the bench. And you said you don't remember that. Is that correct?
Yes, sir. I don't remember that.
Okay. Are you saying it didn't happen or you don't remember it?
I don't believe it happened, but I don't remember it if it did happen.
Okay. Do you remember how in the complaint you knew that you had to go back in May for hearing?
Objection. He's not a complainant.
Yeah, and it's asked and answered. So I agree with your objection and I grant it.
He's already testified. You were never arrested on the writ of attachment. You didn't even know about it till after it had been withdrawn. Isn't that correct?
Yes, sir. That's correct.
Okay. Ask the witness.
Any rebuttal questions, Mr. Robertson?
No, Your Honor.
Any questions from Justice Parker or Justice Williams? Justice Williams, please.
Yes. The complaining document that was referred to that had the blue type on it that was in the I did this and I did that. Yes, thank you. Thanks for bringing that up. At the bottom, it says Norman Olson. That's your brother, right?
Yes, sir.
And it was submitted 4/15/2019. It states that at the bottom, correct?
Yes, sir.
Okay. My question is, did you report to your brother of what happened? And could he have cut and pasted part of your report into this complaint?
No, I did tell him about what happened, but as far as cut and paste anything I've written, no.
Okay. So this is his writing, not yours.
That's correct, sir.
All right. Thank you.
Any other questions? May this witness be excused?
Please, Your Honor.
We have no further questions.
Okay. Mr. Olson, thank you very much for coming and waiting today to testify. We really appreciate it. And you are dismissed and you can leave.
Thank you, Your Honor.
You're welcome. Mr. Robertson, would you like to call your next witness? By the way, this is interesting because your time is up. Okay, your 2 hours are up, but we've injected a lot of questions that justices have, and of course we have cross-examination. So if it's Mr. Richmond, do you think you're going to take the 2 hours in your case in chief?
I certainly hope not.
Okay, so why don't we do something? Why don't we give half an hour more to Mr. Robertson? Would that be sufficient, Mr. Robertson?
Excuse me, Justice Alvarez. Yes, I believe that'll be sufficient.
And we'll give you the same time, Mr. Richmond, and that way we can proceed with the case, okay?
Yes.
So you have half an hour from now.
Thank you.
Okay. I want to call,
No,
I'm sorry.
One more witness. One more witness. I call Norman.
Mr. Robertson. Who do you call?
Norman Olson.
Norman Olson. Good afternoon, Mr. Olson. Thank you for waiting all this time. You've already been sworn in, and Mr. Robertson's going to ask you some questions, and then Mr. Richmond will cross-examine you. If you can put your microphone on, that way we can hear you.
Okay.
And some of the justices might ask questions, okay? I am going to ask you one favor. If Mr. Richmond says the word object, just stop your testimony right there. We'll listen to his objection. And then depending on the ruling, you will, Mr. Robertson will continue, and vice versa with the attorneys. You may proceed, Mr. Robertson.
Thank you, Your Honor. Would you please tell the court your name?
Norman Olson,
Mr. Olson, where do you live?
in Riverside, California.
Mr. Olson, you are related to John Olson?
Yes.
He's your brother?
Yes.
All right. Mr. Olson, are you the person who filed a complaint with the Texas State Commission on Judicial Conduct concerning Thomas G. Jones, who's a justice of the peace in Dallas County, and that cause was given cause number CJC 19-1803?
Yes.
Mr. Olson, that complaint had to do with Judge Jones and a series of lawsuits between you and Ms. Charlotte Smith Carroll. Is that right?
Yes.
And you've been involved in litigation with Ms. Charlotte Smith Carroll off and on for a long time.
Yes.
All right. Let me ask Ms. Thomas to put up Trial Exhibit 3, pages 131 through 141. Are you able to see that well, Mr. Olson?
Yes, I can read it.
All right. The title on that is Plaintiff's First Set of Judgment Debtor Interrogatories. And I'll just represent to you, excuse me, that it's a number of pages long. And I'll just ask Ms. Thomas to scroll a little bit through that so you can see it. And really, all I need to ask you about that, Mr. Olson, is were you ever served with that document or receive it in the mail?
No.
Okay. And then, Ms. Thomas, if you'd show the witness trial exhibit number 3, page 107. This is an order that the judge signed, supposedly granting that in those interrogatories. Mr. Olson, have you ever been served that document or received it in the mail?
No.
All right. Would you please show Mr. Olson trial exhibit 8? And roll down to the motion itself. According to Judge Jones, this is a motion for contempt that was prepared and filed by Ms. Charlotte Smith Carroll. Ms. Thomas, would you just kind of scroll through that? All right, now back up to the top is fine. Mr. Olson, have you ever received in the mail or been served with that document, a motion for contempt?
No.
If you would show Mr. Olson page 94 of trial exhibit 3. Are you able to see that, Mr. Olson?
Yes.
All right. That's an order to show cause and a notice of hearing for April 2nd, depending on which line you read. Did you yourself receive that order either by mail or by personal service?
No.
How did you learn about an April 2nd hearing?
My brother took a picture of it and sent it to me.
Okay. Would you please show Mr. Olson trial exhibit 3, pages 28 and 29? Now, yeah, that's perfect. Excuse me. Mr. Olson, before that April 2nd hearing, you had an email exchange with a court clerk named Haiti Olivares?
Yes.
All right. Can you tell this court what that exchange was about?
It was about me showing up for court on the April 2nd, I believe it was.
All right, sir.
And I was 1,400 miles away. I couldn't make it. I was trying to tell him I didn't know about it, other than my brother sending me the picture of it. So it was impossible for me to make it there. I was asking for an extension, I believe, or something.
And you see the part that's highlighted there in yellow?
Yes, I still don't know why they were going after John Olson. He was never a party to the suit.
All right. Let's see. Let's show Mr. Olson, please, Trial Exhibit 3, pages 23 through 27. All right, sir. Mr. Olson, this is a notice of hearing that supposedly set a contempt hearing for May the 14th of 2019. Did you receive a copy of that?
I seen that notice. I believe it was sent to John.
All right. John made you aware of it?
I believe so. I think it was sent to his address.
Okay.
I didn't receive one in California, best of my recollection.
All right. And did you know what that was about?
Well, since I was CC'd at the bottom, I thought it was against Charlotte Smith for her behavior. I didn't know it was a contempt hearing for anything else other than her behavior.
All right, sir. And you learned, what you learned about the April 2nd hearing, you heard from your brother, is that right?
Yes.
Okay. Did you attend court on May the 14th?
No.
Okay. Did you become aware that Judge Jones had issued a writ of attachment for your brother?
I became aware of it much, much later.
All right, sir. Do you know what a writ of attachment is?
I believe that it's something that can attach assets on a person.
All right. That certainly was. All right. Let me ask Ms. Thomas to show you what's been admitted as Trial Exhibit 9. Are you able to see that?
It's from me.
A little better?
Yes. Yes, it looks like what I wrote.
Okay. Ms. Thomas, can you roll down a little bit? Is that a letter or an email, Ms. Thomas, I guess, back to the top?
I believe it's an email.
All right. An email that you sent to Judge Jones?
Yes.
All right. And you recall the substance of that?
Yes.
And can you tell this court why you wrote Judge Jones in January of this year?
Well, I was trying to get the writ of attachment I became aware of removed against John because John was never a party to this contract. And, you know, the statute of limitation had long run out before well, whatever. But yeah, I just thought everything was wrong and I was trying to work it out. But it was already too late.
All right. And there was a second purpose for this letter, and let me just ask it this way. You have
Your
a,
Honor, I'm going to object to leading the witness.
I'm sorry, Judge, I couldn't hear you.
Sorry about that. There was a big truck going by and I muted myself. Rephrase your question, Mr. Robertson, please.
Mr. Olson, if you can see the document there down toward the bottom, there's a second reason for sending the email.
Oh.
Can you tell us what that is?
I'll read it. Yes, I was trying to evict a tenant of mine, and Judge Jones' court never received the paperwork.
All right. Let me just ask you this. You have a number of real estate or rental properties in the Dallas area, is that right?
Yes,
Okay. And from time to time, it's necessary for you to file eviction cases or other lawsuits against tenants?
yes.
And in whose court would those normally be filed?
Normally Judge Jones' court.
Pass the witness.
What is your opinion of Judge Jones?
I've worked with him for many years. I don't know what you mean by my opinion. Personally,
Well, what exhibit is it? Could we pull up exhibit number 9? Our exhibit number 9.
Exhibit number 9 is the email from.
Wait a minute, it may be the same email. Hold on just one
This one.
second.
Yeah, January 22nd. That's it.
It's the bottom paragraph I think you're looking for.
Well, no, it's the, all right, where it says, the paragraph that says today, which would be.
Excuse me, I'm sorry, which exhibit are we looking at right
The
now?
same exhibit, I'm sorry. It is the same exhibit that they were just speaking
File
from.
exhibit 9.
Exhibit 9. The second paragraph,
I see it.
and it says, it says, I have been in your court many times and I've always found you to be very fair and impartial. I hope you will continue on for many years. Is that your feeling about Judge Thomas?
Yes,
And this is after all this happened. This is in January 22nd. Is that correct?
yes.
And could you go down a little bit further on there? And in the last paragraph, you say to the judge, thank you for your help and support over the last 14 years. Is that correct?
Yes,
And you still are wanting to file cases in his court. Is that correct?
necessary.
Well, there's another court you can file in, another place. And that
Well,
precinct.
I've learned that since January. I wasn't aware that there was another, but now I'm aware of it.
Okay. Now, on the complaint that you originally filed with the commission, can we go back to that exhibit 3? It's our exhibit 3.
Oh,
That would be the original
The
complaint
original
filed.
complaint, yes.
Yeah,
The
the original
commission
complaint, right?
Yeah, dated April 15, 2019. Can you
Yes,
help,
ma'am.
Ms. Thomas?
she can. It's trial exhibit 1.
So that would be trial exhibit 1. It will be exhibit number 3, Mr. Jones exhibit number 3, just in case for the court reporter, Ms. Chapman. Little confusing, but we'll get it done.
Here it is, Your Honor.
Thank you.
Yeah.
Where do you want to go, Mr. Richmond?
Down to the bottom where the actual body of the complaint. Yeah, there you go, right there. Thank you. Now, I think you just said you're the one that filed this complaint. Is that correct?
Yes,
And it says the date of the alleged misconduct of the judge. That date is 6/22/16. Isn't that correct?
I don't know. What are you saying? The date of
The
my
very top line, it says the date of alleged misconduct of the judge.
That would be one of the dates, yes.
Well, that's the date in this complaint, is it not?
Yes, that's the date in that complaint.
Okay. And that was the date that you went to a jury trial with Judge Nash, isn't that correct?
Not sure, I'd have to look it up. There were so many trials.
All right, let me direct you. Well, you wrote this complaint. What happened on 6/22/16 that you were complaining about?
That the statute of limitations had run out, that John Olson was being named as a part of the suit. And this case had already been heard in Judge Jalisco's court because Judge Jones reclused himself. So they were hearing the same case again.
Okay, that was your thought on the matter.
That was my thought, yes.
Okay, and your objection for the major portion of this was how you were treated by Judge Nash. She didn't pay attention to your pleas of res judicata and wrong court and all the other stuff. That was really directed towards Judge Nash, was it not?
Well, I didn't know Judge Nash was going to be the judge until I showed up that day.
Now, I understand that. Your Honor, objection, it's not responsive to my question.
Overruled.
Um,
And Mr. Olson, just answer the question, please.
Yes, ma'am.
About, let me see. About with the sentence starting, the fact 2-year statute of limitations had passed. Do you see that?
Yes.
And then finally, I indicated that Judge Jones had issued a recusal and transfer of venue. Is that you? Okay. Is that right?
He had issued that.
Okay. And all these issues were ignored by Judge Valencia Nash. So it was Judge Valencia Nash that you were concerned about all of these issues. Is that not correct?
I'd say no.
Well, that's your complaint. You said that you're the one that authored it. Who put that in there?
I wrote that.
Okay. Well, why did you write it if it's not true?
I didn't say it's not true.
I misunderstood you. What did you say?
What was the question?
So you said all of these issues were ignored by Judge Valencia Nash, saying all these issues that you mentioned up above, you're complaining about Judge Valencia Nash, not about Judge Jones.
My answer to the complaint that was heard by Judge Nash was directed to Judge Jones' court.
I understand that, but it was a jury trial, and Judge Nash was the judge that presided over the trial. Isn't that right?
I believe so. If
And it
that's
was
June 22nd.
And it was your complaint that Judge Nash didn't abide by the rules of res judicata, and that the statute of limitations had passed, and that it shouldn't be in that court. And it was Judge Valencia Nash that you were complaining about that didn't treat you right in the trial.
All those issues were in my answer before we went to court.
That's, Your Honor, I'd ask the court to instruct the witness to answer my question, please.
Please answer the question, Mr. Olson.
Okay.
So all of those objections that you had in this complaint, and the top part of the complaint, were objections that were in the case that Judge Valencia Nash tried, the jury trial that you lost.
Reading it, it does concern that day, yes.
Okay. And are you aware of the fact that the judge issued and the jury found both you and your brother to be responsible for the judgment? The judgment is against both you and your brother? Did you know that?
Yes,
Okay, so why did you say your brother's not responsible? He's named in the judgment.
my brother was acting as power of attorney for me, and he ended up as part of the suit.
Okay, but
All that was in my answer.
the judgment was against him and you both. Isn't that correct?
Yes, it was.
Okay. Now, the court, the next sentence down says the court has been hostile and we have been escorted to our vehicle twice by an armed bailiff. You weren't even in Dallas at that time, were you?
No, I wasn't.
Okay, so when you say we were escorted, that's not correct either, is it?
That's not correct.
Okay. Now, on down on the bottom, and it says, I am being summoned to court again in May. You weren't being summoned to court again in May, were you?
You talking about May 2019?
Yes, sir.
I was CC'd on there the same as my brother.
Your Honor, I'd ask that the court to please instruct the witness to answer the question that I asked him.
Mr. Olson, please answer the question.
Your Honor,
Yes.
I must say, he answered the question. He was CC'd on that document. It's clear and it's been admitted in evidence.
Is that your answer, Mr. Olson?
Yes,
All right. It says I just appeared on April the 2nd. Was that you? Did you appear on April the 2nd?
I believe that complaint was for John and I.
Your Honor, I object.
No, I wasn't there April 2nd.
All right.
Thank you, Mr. Olson.
And was the violent result when it says or when you're talking about that, the violent result was not you, was it?
No, it wasn't.
And you were not escorted to your car, was it? Were you?
No, I wasn't.
So all of that is false in the statement that you made. Is that correct?
I can't answer that question.
Okay.
You saying the whole complaint's
Can or
false?
you won't?
You saying the whole complaint's false? I don't understand your question.
No, sir. The question I
Just
asked
ask
you,
your question, Mr. Richmond.
the question I asked you was all those I's in the last paragraph, those were John, not you. Isn't that right?
That's correct.
And so if you're saying you filed the complaint, why didn't you say this happened to my brother? And you said it as though you were the person who was that the court treated poorly.
What's the question?
Nah, strike that. Now, you never appeared before Judge Jones on this collection efforts either, did you?
What's the collection efforts?
The money to try to get the collective judgment that you owe Mrs. Smith.
I was never served.
You knew you got a judgment against you. Did you ever pay the judgment?
No.
Do you have, are you still saying that you did not know, even 2 years later, that there were interrogatories sent to you? All of this, you didn't know that?
I don't know what you mean by interrogatories.
Have you ever answered the written questions that Mrs. Smith asked you to answer?
Objection is asked and answered.
Ms. Thomas, Mr. Robertson has the case, okay? So I really ask that one attorney per side who make the objections. You can proceed unless there's an objection, Mr. Robertson.
Well, apparently, Mr.
The court's
Robertson,
heard from me sufficiently, I think.
Okay.
I did not see Mr. Robertson on the screen.
Oh, yeah, there's not enough because we have the exhibit on the screen. There's not enough room for everyone. Okay.
So as we stand here today, you have not paid the judgment and you have not answered the interrogatories. Is that correct?
Again, could you explain what interrogatories are?
The questions that Mrs. Smith sent you about your assets.
I never received anything about my assets.
And you never paid the judgment. Well, you've already said that. Okay.
Everything he knows about this was hearsay from his brother.
Yeah. No, that's the bottom. Yeah. Pass the witness.
I have some questions, Mr. Olson. Okay, going back to this document in front of us, what was your understanding about, well, let me ask you this first. When you appeared to try the case that Mrs. Smith Carroll brought against you and your brother, you appeared, you thought you were going to be before Judge Jones?
Yes.
Did you ever get a notice from Judge Jones or anyone in his court that he had recused himself from the case?
Not since 2014.
But he did send a notice, correct? That he was recused from the case?
No, not the 2016, no.
Okay, got it. Okay, so then you appeared to trial and you're before Judge Valencia. What was your understanding about which judge had the case after your case was tried? In other words, go on.
I thought Judge Jones was just sick or off that day and Judge Nash was filling in because she works at a different courthouse. That's all I thought. I still thought it was all Judge Jones' court and Judge Jones' business. That's why I addressed Judge Jones on my complaint.
Okay, so here in the document where it starts now, in 2019, I'm being summoned to appear monthly due to Ms. Smith filing motions against me. What was your understanding as to what court you were supposed to report to with respect to those motions?
Precinct 1, Place 1, Judge Jones' court.
Okay, so in your mind, you always thought that, just only the trial was transferred, but everything else remained there with Judge Jones's court?
Yes, it always did.
Okay. With respect to those questions that Mr. Robertson showed you at the beginning, the very first exhibit that he showed you, those are called interrogatories because they interrogate the witness. Did you ever have an opportunity to talk to anyone at Judge Jones's court with respect to any documents that were sent to you?
All my correspondence with Judge Jones' court was emails, and I believe you have all those.
Okay, so there was ever a telephone conference where someone said, hey, we're trying to get a hold of you and send you some documents, some questions, etc.?
Not at all.
Okay. Then with respect to those questions, when was the first time that you actually saw them?
You talking about the writ of attachment?
No, I'm talking about the interrogatories, that famous word interrogatories, which are questions. What was the first time? Yeah, those. When was the first time that you saw those?
This goes back to 2013. Is that what we're talking about?
This goes actually, you see the file stamp, May 15, 2018?
Yes.
You see that file stamp? Did you see them anytime before this day?
I don't believe so.
What about the first time you saw them after this date of May 15, 2018?
I don't think I've ever seen these.
Is this the first time at this trial that you've seen these?
I believe so.
Okay. Let's see. There is let me just go through my notes really fast. Now, when you say that, and going back to that last exhibit where you related what happened to your brother in the I subject, okay? Here at the bottom, I have called and emailed the court.
Yes,
You stated that you gave your brother a power of attorney. What did the power of attorney entail?
my brother was working as an agent for me to represent me in court since I live 1,400 miles away.
And do you recall why in this statement, in this last paragraph of your complaint, I guess you talked about what happened on April 2nd as it was for you and not your brother, it happened to you and not your brother. Do you recall why that statement?
That is a mistake. You know, me and my brother are like one, I guess, and that was I felt like I was being done to, but that is wrong. It was my brother. It was not me.
Okay.
So I worded that wrong.
Okay, but you did realize that a complaint of this magnitude would end up maybe someday in a court like this, and it was something you should have not done.
Yes,
Okay, but the fact is that it did happen to your brother, correct?
definitely.
Okay. Any questions from Justice Williams?
Yes. Correct me if I'm wrong. I'm kind of reading between the lines, but I want to make sure that my understanding is correct. Did your brother own any ownership interest in the properties that were at issue in these cases?
None at all.
Okay, so he's only working as like an office manager would, but these aren't his properties, and your confusion is that the claims shouldn't be against him because he has no ownership interest. If there is a claim, it should be against you, correct?
Exactly.
Okay, and yet it wasn't you that was being pursued. It looks like that it was your brother, who's kind of like the apartment manager that's being sued as an owner, right?
Exactly.
Okay, all right. Now I got it.
Judge Parker?
I don't believe I have any questions of this witness. Thank you.
I have one question, Mr. Olson. After the case against you and your brother was tried, did you know that you could appeal this case to a county court? Did anybody tell you that?
I'm not familiar with the appeal process, but I do know it's an option in courts. I just saw it useless with this judge.
Okay, so you were aware that you could appeal to a county court and retry the case all over again?
I believe, yes.
Okay. Those are all the questions I have. Mr. Robertson, do you have any other questions?
No questions of the witness, Judge.
I do, Your Honor. Can I have
Go
just two
for
more
it.
questions? Thank you. I think there was a document that where the court advised you before the April the 2nd hearing that you hadn't been served and you're not responsible. You don't have to show up. Isn't that correct?
I believe it was an email, yes.
Okay, so you knew that that is for the time being anyway. You weren't responsible to show up in court or to answer or to file anything in any of these hearings.
Yes.
Did Miss Smith ever send you any mail that you refused to accept?
Yes.
And she sent you copies of the interrogatories and copies of all these orders, and you refused to accept it. Isn't that correct?
I wouldn't know what was in there because I never got them.
Okay, so you never accepted them. You got them, you just didn't accept them. Is that correct?
I didn't get them. No.
Well, you refused to accept them is the reason.
I have to object, Your Honor. There's no testimony here about anything that was included in any letter from anybody.
There's fixing to be,
There's
Judge.
no way for him to know.
Your Honor, if I'm respond to that, there's getting ready to be some. And he's admitted that he rejected letters from Ms. Smith.
Overruled. He already testified to that. And keep it short, Mr. Richmond.
I think that's pretty much it, Your Honor. That's all I have.
Okay, I'm not going to open it to more questions. Mr. Olson, you've been very kind to wait for us today, and you are dismissed. Thank you very much for your testimony. And you may leave.
Thank you.
You're welcome. Okay, we're running out of time. You ran out of time, Mr. Robertson. You have another witness?
I do not.
Okay.
The commission rests.
What about you, Mr. Richmond?
I have one more witness, Your Honor.
And can you call that witness, please?
I will. It's Charlotte Smith. It's Your Honor, to avoid confusion, she's sometimes referred to as Charlotte Smith and sometimes Charlotte Smith Carroll, but it's one and the same person.
Okay, and I'm going to ask the court reporter. I think she's using the name Charlotte Smith -Carroll, and we'll refer to her as Miss Smith.
I think that's how she's been referred to in most of the documentations. Yeah.
Thanks for making that clarification, though, because some of my questions referred to her as Ms. Carroll. So
it's the same person.
Yes, thanks.
Mr. Cruz, do we have Miss Smith?
Yes, Your Honor. If she could go ahead and turn on her camera and her microphone. Thank you, Ms. Smith.
Hi.
Hello, Ms. Smith.
Hi.
Let me remind you that you're under oath, and if one of the attorneys objects, they'll say object, and at that point, I would ask you to please not continue with your testimony until I rule on their objection. Okay.
Okay.
Other than that, it's Mr. Richmond is going to ask you some questions, and then Mr. Robertson. Also, the justices, Justice Parker and Justice Williams and myself will probably ask you some questions, clarification. Now, you haven't met Ms. Chapman, Carolyn Chapman is right there. She's the court reporter, and she's taking all the testimony. She's transcribing all the testimony. Sometimes she will ask us for a break, so we'll break and then we'll come back just to give her time to stretch her fingers and her wrists, okay? It has nothing to do with anything other than we need to give her the courtesy. And with that said, Mr. Richmond, you may begin. Are you taking this witness as an adverse witness, Mr. Richmond?
No.
No, okay, it's your witness.
My witness. Would you please state your name for the jury, please? For the judges, excuse me.
Yes, it is Charlotte Rochelle Carroll. My maiden name is Smith.
And do you mind if we refer to you as Smith, Miss Smith? Because I think most of the documents refer to you as Miss Smith, and it makes it easier.
That's no problem. That's not a problem at all.
Okay, thank you. Are you the Charlotte Smith that was involved in the lawsuit with the two Olson brothers?
Yes, sir, I am.
You were actually involved in two lawsuits with them, were you not?
Yes, sir.
And I want to draw your attention to the one where you sued them to get your deposit returned.
That is correct.
All right. And how did that lawsuit end?
I actually won by jury trial.
All right. And the judge entered a judgment in your behalf against both of them? Both
that is correct.
Olson brothers?
That is correct.
Now, did you ever do anything to try to collect on that judgment?
I did several things to try to collect on it. I actually asked them to just return my deposit before I even filed a lawsuit. Actually spoke to a lawyer at Ross and Matthews. I have a legal shield plan with them. So I got some advice with them from them on what I could do to obtain our deposit back. If I'm not mistaken, they wrote them. That's even before I filed the actual lawsuit, because I was trying not to file the lawsuit.
Okay. What I'd like to do is to go right to the fact that the lawsuit's over and you've got a judgment against him. Now, what have you done to try to collect that judgment? Yes, go ahead.
Okay. After I filed the lawsuit to collect the judgment, I went to court to file discovery. I call it discovery. I always pronounce it wrong. I call it interrogatories, but I know it's pronounced some other way. I can't pronounce it. So I did go to the court to get assistance to see what the court could do to help me collect it.
Okay. Did you ever send a copy of those interrogatories to the Olsons?
Yes, I did. I sent it multiple times.
Excuse me, you did what?
I sent it multiple times.
All right. How many times did you send those questions to them?
Twice.
Twice. And do you know whether or not they received those questions?
They were sent. I'm sorry, were you done?
Yes.
Okay. They did not receive them. They refused them.
They were both times?
I sent them certified mail and they came back refused. And then one for, what's his name, Norm, came back. He never picked it up from the post office when they left him the message to say, a little sticky that says, you have a certified package to pick up. He never came to get the second one.
All right. Well, what did you do? Did you try to go to the court to get any help to get these, get your judgments collected?
That is correct. Yes, I did.
Okay. What did you do?
I filed, I asked for a hearing on it.
A hearing on what?
On getting the order for the the discovery.
The interrogatories?
The interrogatories.
Okay. Did you have a hearing? Did the Olsons appear at that hearing?
John did appear at one of the hearings. Norm never appeared at any of the hearings.
Okay. So John appeared at the hearing where you were asking the court to order him to answer the interrogatories. Is that correct?
That is correct.
All right. And did he ever ask you for a copy, another copy of the interrogatories, or did he ever tell you he didn't know anything about interrogatories?
He did, and in court, the judge asked me to send him another copy of it. And I told him I would send that certified, which I did.
Okay. Did he pick that copy up?
No.
Okay. So, and this is when, about when is this?
It was, I don't have the exact dates, but it was a hearing we had prior to when I filed the motion for contempt.
Okay. Now let's talk about the motion for contempt. Did you ever talk to anybody in the court about a motion for contempt?
Yes, sir.
Who did you talk to?
I initially mentioned it to Rebecca.
Okay. And what did you say? Did you ask her to, what did you do? What did you ask?
I told her, long story short, that I wanted them to be picked up for evading court and evading me. And she told me that I would have to file a motion for the court to find them in contempt. Because I know a little of the terminology, of course. So I did ask, how do I get this done? This motion, for contempt.
Did you ever have a conversation with the judge about it?
I mentioned it to him in hearing.
And what did he say?
He told me that's something I had to do in writing. Okay.
Did he tell you he can't just go pick people up on your oral?
I actually asked him why can't you just throw him in jail? He said he couldn't do that, that I had to follow law and follow the protocol, and that I had to file the motion for contempt before he could do anything.
Okay. Did you in fact file a motion did you file a written motion in contempt?
Absolutely, I did.
Okay. And how did you do that?
I did it via email. I sent it to Rebecca.
Were you advised that you could do business with a court by email?
I was advised I could do that. And there was a reason why, but yes.
Okay. Now, where were you living at this time?
Arlington, Texas.
All right. So when you have a hearing, you have to come from out of town, or Arlington at least anyway, to the court. Is that correct?
That's correct.
Approximately how many times did you go to court, make appearances in court to try to get these people to pay the judgment?
I don't have a number, but it was so many times. It just drug on and on, year after year. Okay. And you say that you did send them on 2 occasions copies of the interrogatories. The judge and
I think you said that one of the Olsons was in court on one of those requests. And that, I guess, wouldn't be Norman because he was in California. So it'd be John?
No, the only time John showed in the courtroom, in that courtroom, was at jury trial. And that wasn't in front of Judge Jones.
No, John or Norman?
Norman.
Okay. No, I'm talking about John. John was in court on one of those times you were trying to get them to answer the interrogatory. Is that correct?
Yes, that was after they were served with them the first time.
Okay. And the judge told you for you to send them another copy. Is that correct?
That is correct. He said I could do that.
Okay.
I told him I was going to. He didn't tell me to, but I told him I was going to, and he said if that's what I wanted to do, I could, because I wanted a record that I had sent it again, some type of record. So that's why I sent it certified.
Okay. And again, they refused those copies too. So
That
every
is
time
correct.
you ever sent them anything, they refused to accept it. Is that correct?
That is correct.
All right. So now you file the motion. What happens?
I filed the motion. I initially filed the motion. I received an email from Rebecca letting me know when the hearing for the motion for contempt was going to be. And then I also received a copy of the mail. I still have that.
Okay. And so the court notified you, as well as I assume John Olson, that there was going to be a hearing on what day?
It was sometime in April, I believe.
April the 2nd, as of the hearing of April the 2nd.
Yes.
All right. Now, did John appeared at that hearing, did he not?
Yes, he did.
And acknowledged that he got notice of the hearing and he appeared.
He did.
All right. And to tell the court exactly what happened at that hearing.
At that hearing, Judge Jones, he gave me the opportunity to speak first because I was the person who asked for the hearing, as he explained. And so I went into it and I let him know that Judge Jones know that I had served the interrogatories to John and that he was evading the service. So I showed him where I had sent it over certified to them and he wouldn't pick it up. Or he would say is to refuse.
Wait a minute, when you say you please use names instead of he and that, so we know what you're saying. You told the judge what?
Judge Jones that John Olson continued to evade me as far as when I tried to send him the interrogatories, try to send that to him, he would either not pick it up or he would refuse it. Okay. And so that's when I just told the judge what I was there for.
Okay. And was John there while you were saying that?
Yes, to the left side of me.
And he understood that he was there because you wanted him to answer the interrogatories.
Oh, absolutely. There's no doubt. That's what I said I was there for.
Okay. What happened then?
Unfortunately, at that point in time, the judge gave him another chance.
So the judge
gave John another chance.
He passed the case. Is that what you're saying?
Yes, he actually gave him another chance to turn in the interrogatories.
All right. And what was your response when the judge gave him yet another chance?
I was very hurt. I was very upset. I was frustrated because I had been chasing these people down since 2013. It was just year after year after year. They wouldn't show the hearings. I was frustrated. And he gave us the court date and the time because he asked Rebecca to do so, to get it scheduled right then and there. So we both knew what was going on.
Okay. Well, so the case was reset while you and John were in the courtroom?
Oh, absolutely. That's why I was upset because he gave him another chance and reset it for him to give 30 more days to turn in the discovery. And I just didn't think that was fair.
Okay. And did you tell the judge that you didn't think it was fair?
Absolutely.
Did you tell the judge your opinion of what you thought was going to happen?
Absolutely.
What did you say?
I told the judge that, am I to say everything I said to the judge?
Yeah, well, yeah.
Okay. Well, I told the judge how that was just not fair to keep giving them chance after chance after chance. I'm coming here from Arlington, having a drive here for every hearing. They're not showing up for the hearing. I went into telling them the history that I found out about them, how they don't return deposits that they rent to people. They don't return their deposits. You know, I was saying how they're scam artists, Judge. They're thieves. They stole our deposit. I told the judge how my husband sold a car that he had to give them that deposit. And I'm emotional because we were financially struggling at that time. So that was the only way that we had to be able to get our housing. And so I'm telling the judge, this is not fair. You know, this is not right. We keep doing this over and over again.
What did John have to say?
He started laughing at me, and he was saying, ha, 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 loud in the courtroom while I'm talking to the judge. So he just began to taunt me because I was upset.
Okay. And what happened then?
I told the judge, look at him. Look, you know, look what he's doing. I mean, look at him. And then I start saying things back to him like, you think this is funny? This is not funny. And I'm saying, Judge, his brother, Norm, is married to a Black woman. I'm saying, why would you scam minorities? Why would you continue to do this type of thing? You're married to a Black woman. And this is what I'm telling the judge and eventually saying something to John. And then I just told the judge, you know, this is not fair. I don't think this is right. You know, you keep giving him chances. When court comes again, he's not going to show up. He's not going to come.
Okay. Did he show up?
He did not show up.
Okay. And that was the May the 14th hearing. Is that correct?
Yes, that's correct.
And again, to be clear, the judge reset that hearing in open court in front of all of you. Is that
yes,
correct?
He did. He gave us the date and the time and when to be there. And
Okay.
even when I left the court, I came back to get a copy of that hearing that Rebecca had put in. I wanted a copy of it, the paper copy. So I even got the paper copy on site.
Did the judge also send that same day written notice of the May 14th hearing?
Yes.
And did you get it?
I did receive it, but even though I already had it, but I did receive the mail copy.
Okay. So was it sent regular mail and registered return receipt?
I only received regular mail.
Okay. Do you know whether or not it was sent to the Olson, John Olson, registered return receipt requested?
I was told it was because I asked Rebecca.
Okay.
I sent her email.
All right. So John, what happened to John on the? We're still on the April 2nd hearing.
Okay.
What happened to John?
Oh, the security guys ushered him out for the taunting of me when I was talking to the judge.
Did he say? Did John request that he be removed or request protection?
No, not that I remember. No.
Did he ever say he was scared of you or scared?
No, he was too busy, ha, you know, to me to say he was scared. Scared of what?
That was when you found out the judge is going to give him yet another chance, a fourth or fifth chance.
Yes, another fourth or fifth chance.
Okay. Now, did the constable have to usher you out?
Oh, no, sir. No, sir. I walked out on my own and then I came back in to get a copy of the hearing for May.
Okay. Did you leave the hearing before it was over?
No, we were done.
The judge had reset it, told everybody to come back, and that's when you left?
Yes.
You didn't just storm out in the middle of the hearing, did you?
No, the hearing was done. We already had everything said. I said everything I need to say to the judge. The bailiff was telling him he had to leave, get him out of there. So we were done. So that's when I left, got my purse and was out of there.
Okay. When was the next time you had any dealings with the court?
Oh, when I believe we came back for
the May hearing
on the of course the May hearing when he didn't show up, and then at that point I don't remember if I had to file anything else for him to be picked up, but I know that I had contacted Rebecca several times after that May hearing, just getting information. I also spoke to the constable who was going to go to his house. So I was just trying to figure out what was going on from there.
Okay, so you're trying your best to get this guy served and to let him know what's going on.
Absolutely.
And he knows there's interrogatories out there. Is that correct?
Absolutely. Yes, he absolutely knew because we discussed it in court, April 2nd.
Okay. And you, I think you said even before the April 2nd hearing, when you asked the judge to order them to answer the interrogatories, was John there then?
Yes, John appeared at, let me see, it's that one. I asked for the order to be sent for them to do it. He did the order. I got a copy of the order, but I don't think John was there. I don't recall John being there for that one.
Okay. Was he there any other time besides April the 2nd?
Not that I'm aware of, because he kept skipping. So he wouldn't be there.
Okay. So how do you know that John knew that there was interrogatories to be answered?
When we got to court on the 2nd is when I told the judge he was evading me. So at that point, I know for certain he knew about the interrogatories, because that's what we were discussing. April 2nd, and that was the whole reason why I asked for the hearing, because I felt like he was evading me because he was, refusing my mail. So that's when I let the judge know, and he of course knew with the interrogatories, I had them with me. So
okay, did John ever ask to see a copy or say he didn't know anything about them or had never seen them?
He said he didn't know anything about them and had never seen them, which is probably true because he wouldn't accept my mail when I was sending it to him.
Okay. Did he ever ask you for a copy of them?
He did not ask me for a copy of them.
Okay. Now, what happened on the May hearing, May the 14th?
Didn't show up. Told judge, told you. He wasn't gonna
What'd
come.
you say? What'd you tell
I
him?
said, I told the judge, told you. Remember, I told you he wasn't going to show up.
And he didn't show up.
And he didn't.
Okay. Well, what happened?
At that point in time, the judge had told me that he could take the next step and get him brought in to complete the interrogatories.
To answer the interrogatories.
Yes.
To make him answer the interrogatories.
He explained to me what would happen, that he couldn't put him in jail, but because I wanted him in jail, but he could bring him to the courthouse to make him complete them. And then when they bring him in, that they will call me to let me know that he was there to complete them. But he couldn't put him in jail though.
Okay, now when I think you previously testified that you made an oral request for the judge to hold him in contempt or put him in jail or make him answer the interrogatories.
Yes.
And then you were told that it had to be in writing, and then you filed a written request. Is that correct?
That's correct.
And it was filed in an email, and there was an attachment to the email. Is that correct?
Yes, that's correct.
And the email was sent to Rebecca,
Yes.
and she filed it in the court. Is that correct?
I object to the leading nature of all of these questions.
I think she's already
She's not an
testified.
adverse witness.
I think she's testified. to
And
all of
she's already asked and answered most of them.
that. Ruling judge?
Justice Alvarez, you're muted.
I'm sorry?
She said she's muted.
Oh.
And my comment while I was muted was, do not interrupt me. So I hope you have a smile on your face.
I'm sorry.
Okay, I agree with you. It's leading. It's not an adverse witness. So rephrase your question, please.
I will, Your Honor. Your first attempt to get the judge to hold John in contempt was oral or was it written?
My first attempt was in court, asking him to do it.
Asking him,
The
judge.
Judge Jones, yes.
Okay.
Could you specify, excuse me 1 second, could you specify, Ms. Carroll, Ms. Smith, what date that was?
It was the hearing before, I don't know the date, but I know it was the hearing before the April 2nd hearing.
Was it in 2019 or before that?
It was when he refused, when he didn't, I don't have the order because the judge actually filed an order for him to complete them. There was a hearing after that order that when John did not complete the interrogatories. I don't know the date.
Okay, so you're referring to, you appeared maybe in June of 2018? And
I don't know the date, but it's a possibility. I appeared a lot, so it's a possibility.
And the judge signed an order that said the interrogatories would be answered by a specific date, which I believe was August the 10th.
Okay, that could be correct.
Or something like that. Then was there another hearing that you were present at in 2018?
After the order, there was a hearing after, I requested a hearing, I believe it was after John did not complete the discovery. But I asked for a hearing to hold him, I was probably asking to hold him in contempt then too, because he didn't complete them. I don't know the date though.
All right.
Okay, so let me ask you this and follow up. On that day that the court granted your motion to compel John and I believe also Nelson to answer this discovery, there was a hearing and John attended that hearing?
I'm sorry, Judge, it's Norman.
I'm sorry, Norman.
No, oh no, Norman never attended any hearing.
No, did John attend the hearing?
After the order no. The only hearing I know for certain that John was at was the April 2nd hearing. The other ones, he wouldn't show to.
Okay, so when you you know what, I'll ask these questions after the attorneys are done. Okay, sorry for the interruption.
I think, let's see. Yeah, did in the May hearing when John didn't show up, did you ask the judge to take some action?
Absolutely.
What'd you ask him to do?
I asked him if he could arrest him, because that was always my thing, because he defied the judge's order. So I felt like he should be arrested. So of course I'm going for him to be arrested. Okay, and did the judge tell you that he can't arrest him? He can. Yes, he said he could not arrest him, but what he could do is have the constables, where it's something it's called. He gave me the terminology, the legal terminology for it. I just don't know what it is. Where they
writ of attachment.
Yes, the writ of attachment, where they go there and they bring him to the courthouse, and that's what he said he could do to make him complete the discovery. So he could answer the discovery in the courthouse. That is correct. Okay. And do you know whether or not the judge issued that writ of attachment? I know for certain that he did. Okay. Because I spoke to the constable. He called me. Okay. Now, so you checked on it with the constable? Oh, absolutely. They called me and then I would call and check with them and they would tell me, you know, they couldn't find him or they verified his address, et cetera, et cetera. Okay. To your knowledge, it was never executed. The constable never found him. That is correct. I was told the constable never found John. But never had physical contact with him. Okay. Did John ever answer the interrogatories? Never, not even to this day. Has he ever paid the judgment? Not even into this day, no.
Mr. Richmond, I think I interrupted you a while ago and you were going to ask about an oral request that she made at a hearing.
Yes, ma'am. Thank you. My understanding of your testimony was that the first request you made of the judge was verbal, oral in court.
That's correct.
And when you said, Judge, I want you to put him in jail, you asked, and the judge's response was what?
He couldn't do that. He couldn't do that. I had to follow the processes and I had to file a motion for that.
Okay. And is that the motion for contempt you filed?
That is correct.
Okay. And is that what you were told you had to file to proceed to get some relief and get these guys to answer the interrogatories?
That is correct. That's the only way that he could take any action. So that's what I did.
Okay. Did Rebecca also tell you that that's what you had to do?
That is correct. She did.
Did you ever ask her whether how to get this guy in jail?
Absolutely, several times. I would call her all the time.
And what did she say?
She would, same thing. You have to, do a motion. That's something that, you can mention to the judge when you go to the hearing. That was basically her directions.
Okay. Pass a witness.
Mr. Robertson.
Thank you. Ms. Smith, thank you for being here today. Ms. Smith, you were a plaintiff and a defendant both in lawsuits with these Olson brothers since 2013. Is that right?
That is correct.
Have you been involved in any other lawsuits?
Yes, I have.
Okay. Including lawsuits in Judge Jones' court?
I'm not sure of Judge Jones' court, not that I know of.
But others that you know of?
Yes.
Okay. How many have you been involved in?
I have no idea. Had I known that question before today, I would have had an answer for you.
Well, let me ask. More than these two, obviously.
That is
less
correct.
Than 10, more than 20?
These two for sure. I'm not sure on the number.
Okay. I'm also curious about your co-plaintiff in this case, the fellow whose name was on the petition, Javari Perry. Who's that?
That's my son.
Okay. He's kind of dropped off the list here. What happened to Mr. Perry?
He was 18 at the time. So it's the reason why, and also on the lease, is the reason why he was added to the lawsuit.
Okay. Now, over the years, you've come to know the clerks in Judge Jones' courtroom pretty well. Right.
Professionally, I mean, yeah. I mean, I don't know their personal lives, but I know them professionally.
And Rebecca Manaya, you talk to all the time on the phone?
Yes, when I wanted some information, I would call Rebecca.
Okay. Estimate for us how often you called Rebecca on the phone about your lawsuit.
From 2013, I'm not sure it was Rebecca I was speaking to, but you mean from the 7 years, 8 years
Yes,
I've been trying to get my money?
Sure.
I would say maybe 20, 30 times,
Okay.
40 times, so many times, very many times.
Enough that she recognizes your voice?
Oh, absolutely.
Sure. And you've talked to Ms. Haiti Alvarez as well?
I'm not familiar with who she is, but
Okay.
Maybe.
All right. But you certainly even recognize Becca Manaya when you see her now.
Oh, absolutely.
And you go by the office to talk to her as well?
I go when I need paperwork or something like that, yeah.
Do you and Ms. Manaya have friendship, relationship outside the courthouse?
No, not at all.
But you feel free to send Ms. Manaya emails on the weekends?
I sent it to her on the weekend because I completed my paperwork on the weekend, so I just filed it.
And she responds to you on the weekends too, right?
That one time, I believe so.
Okay. Well, you're familiar enough with her that when you send her emails, you talk to her informally, calling her darling Becca, right?
Oh, I'm like that with everyone.
Okay. And you,
That's not anything special.
and you use smiley faces on your emails?
Mhm.
Okay.
That's just my character.
Do you know Judge Jones outside the courthouse?
I do not.
Now, about these ongoing series of lawsuits with the Olsons, you have sued them at least once. Is it more than once?
I believe it was twice.
Okay. And John Olson sued you to evict you from some property, is that right?
Yes, and he lost.
Well, actually, Judge Jasso handled that lawsuit.
Yeah.
And there was a eviction judgment and a money judgment against you. Is that right?
I don't believe so. The way I remember it is he had to pay us for hotel expenses and any damages we had related to John turning off our water during that storm. I think it was 2014, that big storm in Dallas. He had attempted to fix our water heater and he broke it. So instead of telling us, he just left and cut the water off. So my recollection of Judge Hasso is he made him pay us for he deducted it from the rent. I was never evicted, we left. After that, we moved out.
All right. But the eviction case was heard by Judge Jasso's court and there's a record of that, and whatever that says is what happened. Isn't that right?
I would have to see that.
Well, whatever is on that judgment is actually what happened.
If
Whether
I
you
could-
remember
He
it or
already,
not.
she already responded, Mr. Robertson. Please go to the next question.
I would like to see it. I mean, he's making accusations, but okay.
It's in the record. Now, did you know Judge Jones's wife?
Who?
Judge Jones's wife?
Oh, no, I don't know her. No, I don't.
Okay. Do you understand that Judge Valencia Nash presided over the jury trial in your case because Judge Jones's wife was very ill?
I do know that.
Okay. So she was only filling in for Judge Jones when your jury trial occurred. Is that right?
That is correct.
He did not recuse himself from your case. He didn't take himself off your case. She was just filling in for him that day, right?
That's correct.
Okay. And when you prevailed in that lawsuit in 2016, you got a judgment for about $1,400. Is that
I
right?
believe so.
Okay. Now, that judgment sat dormant. There wasn't anything happening in that case for almost 2 years. What were you doing to collect your judgment
Trying to get
between 2016 and 2018?
trying to get the defendants to pay me.
Did you ever have a execution issued on that judgment?
No, not yet.
Did you know that you could do that?
No, I just learned that over the last year or so.
Now, when you had these interrogatories prepared, did you do that or did someone do that for you?
I did that.
Okay. Did you find some forms somewhere to use?
Yes.
And it was your testimony today that you mailed those interrogatories to both of the Olsons. Is that right?
That's correct.
And you did that on your own?
That's correct.
And when you never got an answer for those or got the letters back or whatever, you decided to ask Judge Jones for help?
That is correct.
Now, what did you do to ask him for help?
I asked for a hearing.
Okay.
On the matter.
And did you file a motion of any kind?
I believe I filed several motions, different motions for different things.
Okay, I'm trying to get to the his order granting your discovery, your interrogatories.
Okay, now we're at the point. Yes, I did. I did ask for in order to make them complete the interrogatories.
All right. Did you file a motion asking for that order? Because we don't see it in the file.
Can I take a look at my paperwork to see if I have a copy of it? And
If
I
you
also
have it.
have a lot of my documents on a flash drive.
Sure,
So
if you can.
I'll
do it
have to
quickly.
stand up, yeah.
I'm sorry, Judge, I should have asked you that.
You should have, but let's get going.
I thought she had it right at her fingertips. I'm
No,
sorry.
it's a lot of paperwork going on a long time.
Ms. Smith, do you want to take a small break so that you can look for those documents, or you're okay?
Yes, that would be great because I want to kind of go on my flash drive, but I want clarification of what he wants to see.
Okay, can you please, he wants to see the motion or any request to the court asking the court to compel or to make the Olsons answer your discovery.
Gotcha. Okay, will do. If I could take about 5 minutes, that would be great.
Let's do something. It's 2:10. Let's come back at 2:20. That'll give Ms. Chapman also some time to rest. Mr. Cruz, we'll come back at 2:20.